hello everyone. I hope you can hear me well. It's great to be here, seeing some familiar faces, also some new ones. So thanks a lot for taking the time. I'm also very happy to say that my children are with us in the room, and because I thought that we also need to kind of bring the new generation along. Also, that would be a very good reason for me to be brief, because I don't know how long this will hold well. So I will present some work that I've been involved in with others on predicting court decisions using AI. And we're getting there. Why are we doing this? So when I started working on AI, a computer scientist I'm working with once Marxist asked me, Felix, what's the greatest thing, what's the coolest thing we can ever do with AI law? And I'm still, I'm thinking, this was 8 years ago, when I'm still thinking about it. But at the time I said, I think predicting what courts will decide. Why that? Not just because it matters to those who are actually in court, but also for those who are thinking about going to court. And if you know what a court will decide, it's much easier to actually amicably solve your problem. But even more than that, actually, when we negotiate, when we cooperate thinking about what would happen if there was conflict. So knowing what a court will decide actually answers the question what the legal consequences of our actions are. And I think, to me, that is still the number one thing. And we call this the Holy Grail, or my friend Mons Magnussen called it the Holy Grail, and that's why we're doing this. We also found that while there are many papers predicting court outcomes, this was, or is still, I think, under-researched for UK law. And looking at this in a bigger picture, we see this as a contribution to access to justice. Now, here are the papers that what I present on is based on. And the reason why I'm showing them is actually to show that it is not just me who is involved, but this is actually a team effort. So without the many team members, and there are probably more than 10 of them who've worked on these papers together, I would not be standing here because I'm just a lawyer who has acquired some knowledge about AI, but I'm not the one doing the heavy lifting as regards coding and so on. So what are we looking at? So we are interested in these papers in predicting outcomes of the UK Employment Tribunal. The UK Employment Tribunal is the first instance for employment disputes. So if you are thinking as an employee that your employer has breached your contract, if you think you've been discriminated, then you will try to negotiate, you try to find an amicable solution, but if you don't, then you'll go to the UK Employment. The idea of the UK Employment Tribunal is to provide an easy access, easy procedure, low cost access to justice in employment law, and many people do so. So around 100,000 cases go there each year, so it really matters. You don't need to be legally represented, and if you then decide to go, what you do is you find a form online and you fill that form and submit it to the court. Interestingly, the law provides some high-level guidance to UK Employment Tribunal judges how to structure their decisions, which is a bit of relevance to us. There are no dissenting opinions. So, if you have in a UK Supreme Court judgment in mind, a UK Employment Tribunal decision looks very, very different. It's shorter, there are no dissenting opinions, they're more straightforward. In many cases, these opinions or these decisions don't have reasons. Why? Because procedure allows judges, if the parties do not ask for reasons, not to write them down. That will also become relevant later. So here we are already. On this slide, you essentially see what we tried to do, or what we did in that experiment. We had as a basis facts. That's the orange part. And in a way, you can kind of conceptualize these facts as if you were a lawyer, a client walked into your office and you say, in 15 sentences, can you explain what happened? And please tell me the truth, because I need the truth to predict whether you will be successful in the employment tribunal or not. Then after your client has told you those facts, you ask, so what do you want? Is it about payment? Is it about a remedy because you feel discriminated? And that is the blue part. And then what we did in our experiment, we tried to predict whether the employee will then be successful, not be successful, be partly successful in the employment tribunal, or whether the employment tribunal judge will hand down another decision. Another decision may be a decision where the judge says, I'm not ready to decide. For example, I need more evidence. So that would be another decision. So in other words, we tried to predict win, lose, partly win, and other. In terms of the data set, we have a good data set, which is based on the Cambridge Law Corpus, which is a data set that we constructed that now contains more than 300,000 UK court cases. And there we took the employment law cases ranging from 2011 to 2023. In addition, we have jurisdiction codes for each case. The jurisdiction codes are assigned by the employment tribunal. There are 54 of them, and we could match them to the cases, which will become relevant also later. Now, we looked at these and we concluded that there are many one-page decisions. The one-page decisions are such short decisions that they do not have, usually not have the essentials of what we need. So because what we need are facts, claims, and outcome. And so we excluded all one-page decisions. In addition, we excluded those cases that did not have these three elements, even if longer. So we only kept those cases in the data set that had facts, claims, and outcomes. And so at the end of the day, we ended up with 14,500 cases roughly. So that is just a much smaller portion of the data set. And there you can see that many of these decisions are quite short. Now, what did we do? So we were interested in the performance of different types of models. And that is BERT, T5, then GPT 3.5 Turbo, and GPT-4. And also we wanted to see how humans would do predicting those cases. In terms of the GPT models, we tried three approaches. One is a zero shot. Another was a few shot approach where the model got 2 or 5 other cases, and those cases were randomly selected. Then, in another approach, we chose these 2 or 5 cases from the same jurisdiction codes. So we wanted to see whether GPT did better if the cases were randomly selected or from the same jurisdiction code. So the jurisdictions code would be something like discrimination, breach of contract, holidays. So these are the types of jurisdiction codes we are looking at. So the zero shot prompt is something that I probably do not have to introduce in this audience. Just to say that we had to define the other prediction as a decision by the judge that cannot be classified as win or lose. Similarly, the few shot prediction is essentially reads the same as the zero shot prediction prompt, but in that case, of course, GPT got 2, and in the alternative 5 example cases. Then there were the human experts, and there were 2 of them. They had kind of an expertise level at the level of PhD student. Both of them worked independently. They were predicting these cases based on guidelines. They could use all information they ever wanted to. So they could research everything except this particular case, because we are actually working with past cases. Just by way of background, I did not include this in my presentation. The data set was constructed using these past cases, then using GPT-4 to extract the information. And these were then the cases that everyone was working. And given that these were past cases, of course, it would not make sense if the human experts would look up those cases. So they were not allowed to do this, but otherwise they could take as much time as they wanted. They can look up things. However, because every one of them had to predict 1,371 cases, they did not take much time to predict these cases. So we are kind of probably looking at a maximum time of 2 minutes per case that the humans used, and they very rarely gathered other information. In their annotations, they also had to annotate whether they thought a case was a hard case to predict or not, because we wanted to use that data later. Now, what are the results? This is probably a difficult slide to read, but this is at the same time the most important slide of them. And I'll try to lead you through it. So on the left-hand side, we've got the models, BERT, T5, GPT 3.5, and GPT 4. For the GPT 3.5 and GPT 4 models, we only show the best performing version. And that was in each case the one that had the jurisdiction code few-shot prompt inputs. So the jurisdiction code-based few-shot did better than the random few-shot and the zero-shot. Then we've got the labels: win, lose, partly, and other. And now if we look at, if we start with the F-score, then we can say that the humans did somewhat better than the models. So in our case, all of this only being baselines, the humans achieved an F-score of 0.7 for wins and 0.8 for losses. If you look at the models, they did not that badly. So, if we look, for example, at GPT-4 achieved a score 0.6 and 0.55. GPT 3.5 achieved 0.59 for wins, loses 0.6. T5 did best actually in these categories, 0.7 for loses and 0.6 for wins. So if you compare this with, if you would just randomly guess, you would have an F-score of 0.27, which shows, in summary, that these are encouraging results to start with, I would say. However, now if we go into details, in particular into the precision and recall scores, then we see that some of these scores are really good and others are really bad. In particular, what is interesting is that there are some asymmetries that are striking. In particular, if we start with BERT and precision recall, you see that BERT has a high recall score for wins and a high precision score for losers, but a lower score for precision wins and recall loses. And this kind of cross is present in other models as well. And we don't know why. I mean, I could speculate, but we didn't research this. Now, if we look at some other types of scores, in particular for partly wins and other, we can see that no one did really well in those, right? So interestingly, the humans struggled with partly wins and other predictions. Here, the GPT models did better, but their scores were not great either. What can we conclude from this? It seems that probably we could say partly wins and other predictions are the more difficult predictions, the more complex ones. And so here the humans did not, in terms of baselines, exceed the AI models. I mean, one thing that, being a lawyer, that we then started to think about is if you predict court decisions, what do the scores tell you? And thinking about this, we discovered that, or we think that precision is a good score if the cost of a false positive is high. That means precision is a good score if the cost of the model telling you should go to court are high. So let's say if your litigation costs. On the other hand, a recall score is a good score if the cost of a false negative is high. So in other words, the model tells you don't go, you will lose. You would have won, however. So that is the case, let's say, if what you would have gotten is emotionally or monetarily important to you. So I thought this may be interesting for maybe the lawyers in the room, if there are any, so that we kind of start connecting to the statistics. Now then, we aggregated the win and the partly win scores. In essence, that would be a situation where your lawyer would say, well, you know, the client comes and as a lawyer, the client, well, you will win something. Maybe you will entirely win, maybe you will win something. And you know, unsurprisingly, the scores go up. So that's probably not a surprise, and essentially shows that you know the more you aggregate your scores, the better your scores get. Not a surprise. More interestingly, I think, is if we look at the results for the hard cases. So these were the cases where the human experts said, this is a hard case to predict. And in those cases, as we would expect, both the human experts and the models did worse. However, here now, the models did better than the human experts. In particular, again, T5 and BERT did better. So in each case, kind of the both scores are the best scores. I should emphasize that all of the scores that I've presented are baselines only. Right? So all of these scores could be better. We could have put more, more time, better training, and so on, better data into any of those. And similarly, the legal experts could have, taken more time, done more research. So we're talking about baselines only. Now, limitations. So what I've presented suffers from severe limitations. I think one of the most important ones is that we are not working with a court file or information that you would have if you were sitting on a case as a judge before you decide. Instead, just to summarize again, what we did is we took past decisions, extracted facts, claims, and outcomes from these past decisions using GPT-4. We've published those results in another paper, and in summary, we can say that the extraction results are really, really high in terms of accuracy. So we also kind of hand tested them, and we've got scores. The worst score was 90%. Some of the scores were 99% accuracy, and we've got confidence of 95% for each of them. So the extraction results were really, really good. However, in essence, our inputs are the voices, is the voice of GPT-4 talking to us, right? So that is GPT-4 telling us what happened in the case, telling us what the claimant wanted, and labeling the outcome as win, lose, or other. So what we did is we checked in another paper, we checked the accuracy of that, and the accuracy is really, really high. Of course, there may be information leakage. What I can say as a lawyer, having read many of these, I didn't detect leakage myself. However, it may well be that there is. Also, of course, there are mistakes in this automatic information extraction that we did. And also, we didn't do things such as check the evolution of law over time. What we did, however, is that the cutoff 2011 is a cutoff where after that not that much legal change was going on. So kind of the law was relatively stable in this time. So to conclude, I think the baselines are promising. We want to do further work on this and are actually, kind of in the process of doing so. We want to push this forward. We think there's a lot to be done, in particular, doing such work on UK law. We saw variations of the scores. So some of the scores really low, also kind of to emphasize this. And I hope I've kind of managed to at least pinpoint the most important limitations that we're working under. with this, I conclude, and I'd be really interested in your thoughts, questions on this, and thanks a lot for hanging through this really hot talk. Not because I'm a terribly good speaker, but because it's really, really hot in this room.
Are you taking in any new PhD students?
Yeah, I mean, like, I'm always happy if people apply. So, I mean, we've got the general applications procedures on faculty's website or the Cambridge's website. Maybe if I may use that opportunity to speak about PhD projects in this area, if that is of interest. I think if you're thinking about doing a PhD in applied machine learning applied to law, then you'll meet the challenge that you need to define what the research question is that you're actually addressing and what the scientific advance is that you're trying to make. Because now in a classic, maybe legal PhD, you would say, oh, I am advancing the understanding of X law, or I am analyzing law so-and-so using that method. But now, if you do something similar as we do here, then the machine learning methods that we apply are not terribly exciting, right? So we're applying standard methods. So the question arises a bit for your PhD project, what is it actually that you're advancing? So now in our case, I think what we're advancing is we're not advancing machine learning, we're advancing the application of machine learning to law, and we're advancing maybe the analysis of law. So, with relatively basic methods, and if you've got a good data set, you can find out many things that are terribly exciting for lawyers, not very exciting for machine learning experts. So I think that is a bit of a challenge, I think, when you develop a PhD project in this area, like to ask, what is it actually that I'm contributing? So in which area am I contributing? Now, if you're contributing in machine learning, then I would say it is the computing department that is your department. If you're contributing in law, then it's the legal department. And the question then arises, what is it in law widely conceived that you're actually contributing? I think that is a challenge for such PhDs. However, I do think that there is definitely value in such PhDs projects.
Get you my ideas later.
Let's talk later, sure, yeah. Thank you.
Amazing. We have another question.
Thanks for sharing very good students, sir. My question is, I'm curious to know what kind of cases do you categorize as hard? And what is your initial hypothesis that why the human experts were not able to predict what the model?
Sorry, why the human?
The human experts were not able to predict the results as good as the model.
Yeah, good question. So how did we classify cases as hard to predict cases? So these were the human experts themselves. So they, when they went through, they had the great pleasure of going through 1,371 cases, and they had one field in which they could tag a case as difficult to predict. So this was their subjective perception. And I mean, if you look at the results, they were actually right, because the ones they predicted as hard, they did less well in.
But they only had 2 minutes, right, per case.
Yes, so they
A very short time.
Short time, yeah. Very short time, yeah. Why did the models do better there? I mean, one thing that we can, like, if I look, I think probably, I would guess that there are around 300, maybe 400 papers doing something similar. I haven't read them all, but having read some of them, my impression is that the models are really good in complex situations, and sometimes they may capture complexity better than human experts, which is somehow confirmed by our baselines. But because these are only baselines, I wouldn't give too much on the exact figures that we're presenting. So I guess that is where the rest of what I could say is speculation. So I better stop there.
Thank you so much for your talk and also the information extraction paper, which my questions relate to. The first is in the second part of the paper, you spoke about creating a data set which could potentially be used for fine-tuning a model which can perform prediction. So I wanted to ask if that's potentially on your research roadmap to take one of the machine learning models, fine-tune it on a data set that you've extracted. And in that case, any thoughts on how you might sort of balance it against humans having a fair shot so they're not making the same determination in 2 minutes? And the second part is in the paper, you also speak about the aspect of how under the EU AI Act and Recital 41, now 61, you have the potential of some of this being classified as a high-risk AI application. Do you think this applies to any attempt to predict court decisions or just with the use of those applications by judges?
Yeah, thank you. So, I mean, like, so what we are trying to do is I'll speak about the data set that we have. So we have a data set called the Cambridge Law Corpus. And if I may go back to my personal history, you know, I mentioned Mons Magnussen when we spoke. That was 8 years ago. You know, we set off for this project, and when I told him, yeah, I think the coolest thing we could do is predict cases, then he said, yeah, let's do that. And then he said, yeah, then we need a data set. And then I said, yeah, we don't have a data set. So actually, the first thing we did is like spend 3 to 4 years on creating a data set. And so we have created that. It's called the Cambridge Law Corpus. It's available for researchers. So if anyone in the room is interested in that, we are happy to make that available. We in order to comply with laws and also ethical principles that we've established, there's an application process with some limits. So for example, we exclude the analysis of individuals and natural persons and entities. Now, this data set, the idea of the data set is that we want to grow it. So whenever we have a project, we merge the data that we generate back to the data set. And, you know, in case anyone is interested in running an experiment with our data set, we are always grateful if you would do that, but we don't require it. In terms of moving forward, our current project is that we now want to move on to predicting the individual remedy, the specific remedies. I mean, because currently our project only predicts, you know, win, lose, partly win, other. So now we want to go into more specific predictions. That's what we're doing. And in terms, we're currently working on that. We haven't figured out the specific approaches that we take. I can say that as an academic, we are limited by the resources that we have. So we have much less resources than commercial players. And sometimes, you know, when I pitch my ideas as an academic, then I get the question from others, and they say, look, commercial players are doing what you are doing just much better, with many more resources. So why do this? I think there's an important reason for us to do this, because we are the ones who bring it out into the public, into the discussion, even more limited, I agree. But I think it's important that, you know, science and academia and also the crossover between law and machine learning accompanies this process. Because I think, you know, a friend of mine once said, you know, when we were talking about lawyers, academics, and judges. And they said, you know, the lawyers have money, the judges have power, and you academics, you know, he's a judge, you academics, you have neutrality. So it's not power, it's not money, but we're neutral, right? So I don't have an agenda. I'm there to say what works and what doesn't. And if I produce a paper with bad scores, I'm fine with it, you know, I'll present it. So I think that's why we're doing that. Not sure, you had a second question.
It's for the EU AI Act's application.
Right, yeah. I mean, like, just to say, so the reason why we limit the availability of our data set to researchers is that it gives us a lot of privileges. It also takes us, that's one reason. I mean, what we are, this is research that we're presenting. So, and that's very different. So that's why we don't have problems with the EU AI Act. It would be very different if this was a tool used by a court. And this gives me an opportunity to emphasize that much of what we do sometimes is we just want to see how it works and what it does, but we're not saying this should be used in a certain way.
So I had a follow-up question similar to some of your comments about industry. So you know this legal company, legal tech company, Clio. Have you heard of it? Okay, yes. So about a year ago, one of the founding lawyers of Clio gave a presentation that really kind of touched on something you mentioned here, which is that say that the models you're using here, they don't have access actually to all the same ground truth that say the judges do. Therefore, if you don't have access to the same ground truth, then how can you actually make the same quality of judgments, right, without that data? And his claim was that, in Canada, we have to actually change the laws and regulations about what type of legal data, such as data inside law firms, can be either grounded against or used to train models. Are you seeing that really as one of the big kind of next steps in research and maybe policy that has to be tackled to bring these F1 scores up?
Yeah, I absolutely do. Just yesterday I was asked to give a mini 5-minute presentation on how legal research will change. And I think my main message was that I think legal research will become data-oriented research. And so law researchers will start searching for data, gathering data, creating data sets, and then storing data sets. And our legal rules are currently not ready for that. For many countries, we find in terms of IP, in terms of data protection, these laws were not made for what we are doing here. And I think we need a debate and we need legislative action to get this on the right track. Generally, my tendency is to encourage, in particular, lawmakers to think about the value of data as a public good. And I think there are also innovative solutions to solve very legitimate reasons for data protection and confidentiality. I think, there are individual reasons, there are business reasons why some data should not become public. But if data can advance our societies, then we should, think about that. And I do think that legislatory action is needed because liability questions, IP questions, data protection questions cannot be solved by private actors via contract. So I do think that we need kind of state action there.